In British Columbia, the law provides that a person who's in physical possession or control over premises has a duty of care to see that another person and that person's property is reasonably safe in using the premises. This area of law is referred to as Occupier's Liability law, because under BC legislation, a person who's in physical possession or control of property is called an occupier. This law often comes into play when somebody suffers a fall at a grocery store or restaurant, or slips in a parking lot, or falls down uneven stairs, or trips on an uneven sidewalk. Notice, however, that I also said the law applies to people's property. People's personal property, in fact, such as vehicles, are included, and damage to those items can be included in a claim against somebody maintaining unsafe property. While we don't like to think of domestic pets or farm animals such as dogs or horses as property, as they're often more a part of the family, the law considers them to be property and provides that these creatures should be reasonably safe in using another person's premises as well. The majority of cases, however, where this area of law is argued relates to injuries to people. Some people believe that if they injure themselves when they're on another person's property through no fault of their own, that the owner of the property is automatically responsible. This is not true. The law only requires a person to take reasonable steps to see that another person on their property is reasonably safe in using it. In other words, the law does not require perfection in ensuring the premises are absolutely safe. The most common example of injuries on premises are slip and falls on residential or commercial property due to slippery substances like water or ice or food. In these cases, the law requires a person controlling the premises to exercise a reasonable standard of inspection and maintenance for the hazards. This does not mean that the occupier will be liable for any accident, only an accident where reasonable inspection and maintenance could have avoided the accident. For example, the courts have found that grocery stores in British Columbia should do regular inspections of their floors about every 30 minutes to 2 hours, depending on the type of store, the area of the store, and how busy it is. As long as the store has a system to ensure the inspection is occurring and can show that it actually occurred, the store may not be liable for an injury even if somebody innocently slips on something such as grapes in the produce aisle. This is a good example. Imagine you walked into a grocery store and 10 minutes before you came along, another customer spilled grapes on the floor without noticing. Could totally happen, right? Then you come along and slip on the grapes before the store employees had a chance to notice them or clean them. You fall hard on the floor, perhaps breaking a hip, a leg, or simply injuring yourself. It is possible the store could not be liable for your injuries, provided they can show the system they had in place was reasonable and it was followed, even though the grapes were on the floor for several minutes before you stepped on them. Again, the law does not require perfection or for the occupier to be responsible for any serious injury. Rather, it only requires the exercise care that is reasonable in all of the circumstances to avoid a hazard. That said, I continue to be surprised how large and sophisticated companies such as national grocery store chains either fail to have an effective system of inspection and maintenance or simply do not follow it. I hope you've learned something from watching this blog. You can watch other videos on our YouTube channel below. Thank you. If you have questions about this issue or another legal matter, please contact us for a free legal consultation. Thank you very much.